Muy buenos días a todos ustedes. En nombre de la International Chamber of Commerce México, les damos la más cordial bienvenida a nuestra sesión remota del Comité de Arbitraje Nuevo León. Les recordamos que nuestras reuniones se rigen bajo el protocolo de competencia económica de nuestra organización, que se encuentra integrada en nuestra convocatoria. Con respecto a esta sesión, les recuerdo que hemos enviado algunas recomendaciones, por lo que les pedimos por favor mantener su micrófono en silencio. Al finalizar la exposición tendremos oportunidad de recibir sus preguntas, para lo cual les pedimos por favor levantar la mano en su aplicación o solicitarlo en el chat de la plataforma para que podamos darle las palabras. Como saben, esta sesión se llevará a cabo en inglés, pero en caso de que ustedes decidan hacer alguna pregunta en español, lo podrán hacer y los miembros de la mesa directiva del Comité Nuevo León nos apoyarán para traducirla. Sin más, damos inicio a nuestra sesión, para lo cual le cedo la palabra al doctor Carlos Leal Garza, presidente del Comité de Arbitraje Nuevo León de ICC México. Adelante, Carlos.
Muchas gracias, Laura. Muy buenos días a todos. Bienvenidos a nuestra sesión del Comité de Arbitraje Nuevo León. Hoy estamos de manteles largos, tenemos un evento de primerísimo nivel. La verdad es que estamos muy contentos de tener a nuestra invitada especial de honor, Lucy Reed. I'm going to speak a little bit in English so that we are all on the same page. I'm welcoming to the event, Lucy, and I'm mentioning that we are very happy and feel honored to have such a distinguished person as you are with us in today's committee session. Bueno, y pues a manera de poder iniciar con una presentación adecuada para el evento que nos estamos proponiendo para hoy, pues es un gran honor también el contar con nuestro presidente nacional de ICC, el doctor Klaus von Boeser, y con el presidente de nuestra Comisión de Arbitraje México. La realidad es que hay muchas cosas muy negativas de esta pandemia, pero si hay algunas pocas, cuando menos, que se pueden rescatar, creo que es esta, que es el poder tener una sesión de este nivel pues a través de estos medios. Entonces, la verdad es que estoy muy contento y cedería la palabra al doctor Klaus von Boeser para que nos diera unas palabras de bienvenida.
Muchas gracias, Carlos. I will switch to English. I assume that everybody that is participating today speaks English. So thank you very much, Carlos, for the invitation, Camilo, for organizing this fantastic conference for today. Thank you very much, Alejandro. It's a great pleasure being able to join this session today. Lucy Reed, welcome to Mexico, virtually, but welcome. Lucy has been a friend of Mexico and of ICC Mexico. I have had the privilege of working with Lucy in many different capacities, different roles, and there's some very interesting cases in our life as arbitration experts. And it's fantastic, Lucy, to have you today to talk about what is going on in international arbitration today. We had as well the pleasure to organize our conference last year with ICA and ICC Mexico, which was one of the best conferences we've ever had in Mexico. It was a great conference. And this year in March, we had as well, together with ICC and with ICA, we had organized a conference to celebrate the 100th anniversary of ICC. Unfortunately, due to the pandemic, we had to cancel it. We were going first to do it part in presence, physical presence, part virtual. And then at the end of the day, we had to cancel the whole thing. We really were not prepared technologically to do it by Zoom. We didn't know Zoom that well at that time. And it was a fantastic program, probably one of the best programs we would have ever had in Latin America. But we'll probably redo that next year together with ICA. So the invitation, the program was only postponed, not canceled. And of course, everything we have learned in the last 5 months, I would say, has really changed the arbitration and will change, I think, arbitration forever. I think since I'm in this field, of course, arbitration has changed. We started with typewriters, no internet, no even electric typewriters. When I started with the court of the ICC, as a court member in the year of '82, briefs were 50 pages long, and those were really long, really long memorials. And arbitration was conducted in a very, very different way, of course. With the technology, things completely changed, and now great part of arbitration is done with electronic means. Electronic means which we command, and as a matter of fact, now we can help the judiciary to implement those systems, because making filings of big documents, we know how to do that in arbitration, and I think we have a lot to convey to our court systems, which are getting into that direction. But now, of course, in arbitration, we have gone a step further in doing virtual hearings, which really had very limited for very limited purposes in the past, and now really are taking off, and that will be I believe, one of the topics Lucy will address today. So thank you very much, Lucy. We'll really enjoy listening to you, and very grateful that you took the time to be with us. And so, as we say in Mexico, nuestra casa es tu casa. You are in your house. Thank you very much.
Estás en mute, Carlos.
Ahora sí. Muchas gracias al doctor Klaus von Boeser, y a continuación pediría al licenciado Alejandro Garrio que nos pudiera compartir unas palabras introductorias también. Thank you very much, Dr. Klaus von Boeser, and I would now appreciate Mr. Alejandro Garrio to address some introductory remarks.
Muchas gracias, Carlos. Igualmente, al igual que Klaus, voy a hacer mis palabras en inglés. Thank you very much, Carlos. It is a pleasure to be here with you today in such a fantastic session. It is a privilege to have the second day of what we have called the ICC Arbitration Week, which we started yesterday with the session of the Commission in Mexico City. But as Klaus has mentioned, today's technology allows us to have the possibility of joining meetings everywhere and with presence in every part of the world. I think that we have to be very, very happy to have Lucy Reed with us. She has, with her experience, been in a position to address us in the topics of international arbitration, which are of most interest today. But not only for herself, but as we know, ICA is a fantastic organization which has been dedicated to arbitration worldwide. And if we see ICA's publications, we can see why Lucy is in the position to address us that she is. When we see the International Handbook on Commercial Arbitration, which covers arbitral law and practice in more than 70 countries, it's a great job. And also, when we see not only the other works, but the reports that ICA has published in the past, and which, even though they have been published in the past, they are current. And I'm sure that Lucy will talk about some of those topics today. When we speak of issue conflicts in international arbitration, that is a report that was issued some time ago, but today, with the ICSID new works on ethics for arbitrators, is of a great actuality. Third-party funding, cybersecurity and data protection in international arbitration, and gender diversity in arbitral appointments and proceedings. Those are topics which are of great value as of today. And I think that that is fine just to mention. I am very moved to see that ICA is such a grateful also organization. When ICA decided to publish a volume in memory of Johnny Bitter. Johnny Bitter, as we all know, was a great arbitrator. Some of us who had the opportunity to meet him and to arbitrate with him know of his capacity, of his sense of humor, of the way he was. And when we see ICA publishing a volume in memory of him, publishing his participations in the different congresses that ICA organizes every year, I think that it was something that shows not only the technical quality of the organization, but also the human of its components and how grateful an organization as ICA can be. So without any more, I repeat that we are very, very fortunate to have Lucy with us, and we're waiting, Lucy, for your enlightening comments. Thank you very much for being with us, Lucy.
Muchas gracias, licenciado Garrio, por sus amables palabras. A continuación, vamos a hacer una breve presentación de la reseña curricular de Lucy. Para ello, quisiera aprovechar para dar la bienvenida a mis compañeros vicepresidentes de la comisión del Comité de Nuevo León, Gabriel Cavazos y Camilo Vázquez. Y al mismo tiempo quiero aprovechar para dar la bienvenida a todos los demás miembros de nuestra comisión, de nuestro comité, y en especial pues a todos los que se dieron el tiempo para acompañarnos. Quiero destacar la presencia de la ministra en retiro, Margarita Luna Ramos, bienvenida. Y pues bueno, de todos los que nos acompañan ahora, la verdad es que estamos muy contentos de tenerlos a todos ustedes. So I was just briefly acknowledging the presence of everybody, all of the members on the commission and of our Nuevo León committee, and all of the members, and especially the retired Justice Margarita Luna, who joins us in this event. So Camilo, if you would please help us with presenting Lucy's resume, please, I would appreciate that.
Of course, Carlos. Thank you, Lucy. As my colleagues have said, it's an honor to have you in this committee session. Well, we all know Lucy Reed, so I will mention a brief resume from Lucy. Lucy Reed is president of ICA, currently is an independent arbitrator with arbitration chambers in New York. From 2016 to 2019, Lucy was the director of the Center of International Law and professor of practice at the National University of Singapore. And before her retirement in 2016, led the Global International Arbitration Group of Freshfields, Brughaus, Derringer. Now a vice president of the SIAC Court, Lucy has served as a vice president of the ICC Court, chair of the Institute for Transnational Arbitration, and president of the American Society of International Law. Carlos.
Thank you very much, Camilo. I would like to now give a very brief introduction to our topics before we start with the interview to Lucy. Well, of course, we would have liked to present all of the experience that Lucy has had in the field of arbitration, but I certainly concur with Camilo that we all know Lucy, so I think we can skip that. We may want to remind that she has been recognized as one of the top experts now as an arbitrator and before as a litigator or counsel in arbitration by chambers and partners, and she has been recognized in many fields as the expert she is. So I would like to give a very brief introduction to our topic. I think both Mr. von Bowitzer and Mr. Ogario did a very well introduction on the general topics, so I will be brief. We'll know that arbitration evolves. That's a fact. It has done it since the last decades. And as such, there are new topics that become relevant. Some of them obey to the proactivity of experts in specialized institutions, which more commonly integrate task forces or committees of experts. That's a way in which arbitration tries to adjust and to adapt to new needs and try to evolve, tending to improve itself. But in some other cases, the trends correspond rather to the needs that derive from the practice itself, or even to they suddenly appear. And certainly they require attention. I think that is the case specifically of COVID that we are all living. So in both cases, it is of the highest interest to dedicate time to better understand these issues and to identify the alternatives that are being considered. So to such a relevant endeavor, and an event like our today's session is a very suitable scenario. As we are able to listen to an expert's view and then to discuss about the ideas that are going to be presented. Such a task becomes especially interesting when one can have an expert of the statute of Lucy Reed, who is an absolute authority in the field of arbitration. Basically, she has been in all of the areas of the practice. She has been a government agent in mass claims tribunals, Ireland, US, an attorney representing parties in investment and commercial arbitration, arbitrations of the highest profiles. She has been a law professor and now an arbitrator, and she has been basically everywhere in New York, in Hong Kong, in Singapore. So she's a reference to everybody. And I think that is what makes it so interesting to listen to her views so that we can start from there to listen to our other experts who are in this session. And from there, try to get the best ideas possible in order to produce new proposals to continue the development. So based on that, I would like to start with the interview, Lucy, if you don't mind. So basically, the first topic that we would like to address is we know that there is a draft of code of conduct for arbitrators, that is being worked by ICSID. And this is a project that has been considered necessary in several ways. And so we would like for you to ask what do you think about this project, where it stands now, and in general, what we can expect from this project.
Thank you, Carlos. And if I may, I'm going to fall back into my new role and habit of being a chairperson of arbitrations in order, before I get into your topic, I just want to thank everyone for having me today. I am behind a bit, or when I left Singapore, I was behind on some arbitration awards, so I've been limiting my webinar participation, but I could never say no to Carlos, who was one of my first and favorite interns at Freshfields. My gosh, almost 25 years ago, let's admit it. And I can say the same for Francisco Gonzalez de Castillo, with whom I'm very close. And I see other friends on the screen from ITA, from ICA, from the ICC. I just mentioned a few. Klaus, thank you for your kind words. Eduardo Siqueiros, president of your organization, Agario, Jose Maria, I see, Luis Enrique Graham, Carlos Lopereña. So I've gotten very good at being virtual, but it's not the same as being in the room and being able to really talk to such good friends and welcoming friends as you are in Monterrey and through Mexico. Again, I apologize that I have to speak only in English. When I'm asked in informal interviews how I did so many things in my career, one answer is, I don't know. And the other answer is, I cut corners like not keeping up foreign languages. So here I am. Thank you for participating in English, and I hope that you all are staying safe and healthy. So ICSID and UNCITRAL Code of Conduct. I just did a very interesting webinar on that a few weeks ago, including with Jose Astagarraga and Juan Armesto. And I'll say, as I said in that webinar, the first thing I want to say is about Johnny Veeder. I very much remember Johnny Veeder, I think it was in an LCIA court meeting many years ago, standing up and saying, if we arbitration practitioners don't try to put together codes of conduct, as difficult as it is, other people, legislators, will do it for us. And they don't understand the community. And I agree with Johnny on that. And therefore, my overall view of the draft code of conduct is that it is good, because it has led to a almost global conversation about the very difficult issues of what aspects of a code of conduct we share in investor-state arbitration, and therefore we find out what issues we don't share principles on. We don't agree on what are the best practices. So as Catherine Rogers has said, it's extremely difficult. It's probably impossible to come up with a code that everyone will, well, it is impossible to come up with a code that everyone can live with, but having the conversation is extremely important, and it's good that we're trying. And I urge those of you who are following the code to take advantage of the comment period, which I think ends in September. Now, having said that I think it's very good, what I'll do now is just highlight a few points that I think are very problematic in the draft, and they tend to be in bracketed language, so it's no secret that they're difficult issues. And I won't go in, some of you may not have read it, so I won't go too much into the draft numbers, paragraph numbers or whatever, but I have a lot of overall issues with, as do others, with Article 5, which are the disclosure obligations. Now, in my experience, disclosure sounds good. The more disclosure there is, the better. The more we understand as arbitrators that we have to have a continuing disclosure obligation, the better. However, it's very important to remember that once disclosure obligations that are detailed get put down in black and white in a code of conduct, particularly since they're continuing, they can be abused for challenge purposes. And they can be abused to limit the flexibility of arbitrators. So, for example, one of the requirements in the code in Article 5 is that arbitrators, candidates disclose all the cases they've ever done as counsel, arbitrator, or in another role. The purpose of that clause is to try to get out repeat appointments. So you can see whether I have been appointed by the same company several times or the same law firm several times. And yet it doesn't say that specifically. I don't think that I could list all the cases that I've ever done as counsel in 45 years. And if I miss one that someone knows about, then that could lead later to a challenge to me or an objection to me for having made a flawed disclosure. I think we all know there are parties that take advantage of that. Another requirement is that an arbitrator candidate list all publications ever written, bracket, and relevant public speeches, bracket. It doesn't say all relevant publications, it says all publications. So technically, I would have to start disclosing, although it is on my CV, my law school note on criminal evidence, which makes no sense. And relevant public speeches. Again, if people were to take this to the extreme and abuse it, it would mean that I have to disclose this webinar because it's a public speech. Now, I have no problem with including on my list of public talks or speeches that I'm doing this webinar. But if it got to the point where I have to be prepared to say exactly what I said or what positions that I took, not only in a disclosure in a new case for which I'm being considered, but remember this, as Juan Armesto stresses, I would have to write to the parties in every single case in which I'm sitting as an arbitrator to update my disclosure statement because it's a continuing obligation. So I think that there's some mischief there, and we have to be more realistic. Another point I want to raise is Article 6, which I'm sure Francisco maybe will join forces on this later, and that's multiple roles, primarily the issue of double hatting. And what the rule says, the draft says, and I'll read it, is that a candidate or an arbitrator has to refrain from or disclose acting as counsel and arbitrator at the same time within 5 or some other number of years involving the same parties and the facts, same treaty. I'm publicly on record as being against double hatting. We can talk about that later, but this misses the main point of issue conflict, which is the problem with double hatting. It doesn't say that the disclosure should be focused on the fact that fair and equitable treatment is coming up in your cases, and if you have written something that, in fact, you shouldn't be writing something that says you're never going to find fair and equitable treatment in a certain set of facts. But if you have, then that would come up. It's just not narrow enough for real issue conflict, which is rare. I'll mention also Article 8, which is availability of arbitrators. And here there's bracketed text that says arbitrators should consider disclosing, I'm sorry, I'll start that over. Arbitrators should refrain from sitting in more than X number of cases at a time. A set number. It might be 10, it might be 5, it might be 20. They've left that blank. I'm very troubled by this idea. And I put David Caron of ITA and Berkeley, and the late David Caron, in the same category as Johnny, as people I most admire in the world. And I have followed up on a paper that David wrote that he calls The Rule of X, where it was a speech that David gave at MIDS shortly before he died, where he said, arbitrators have an individual responsibility to set the number of cases that they can do responsibly. And that's the number X. The number X is a subjective. It's got to be not a code of conduct obligation. It's got to be a personal obligation. For one person, for example, the example we get is the dean of Harvard Law School, say, should not have more than one case because he or she has too many other things to do. Some people can manage 20 responsibly with my colleagues. It really depends on whether you're chair or a wing, if it's in a treaty case or a commercial case, whether it's a lot of money or a little money. It's something that I think would be a terrible mistake to put a specific number in. We would lose a lot of good arbitrators. And of course, there's the question of how do you enforce the code of conduct. So to wrap up a long answer, I think the dialogue and the conversation is incredibly important, but we have to, in the comment period, point out potential mistakes that would harm our practice rather than help our practice in at least investment treaty arbitration. So there, Carlos, I don't want to, well, this is not off the record. I don't want to see all my views in Global Arbitration Review tomorrow, so because I've been public. But I feel strongly that we have to pull back on some of these ideas that come from academics rather than practitioners. You're on mute, Carlos.
Okay, I'm sorry. Thank you very much, Lucy. Before we elaborate to that, I would like to move on with the next questions, and then we will open the floor for the discussion of all the topics that you are going to be addressing. So somewhat related to this topic that you discussed about, it's another one, which is the standards of practice on civility. You were mentioning the code of conduct, which is more applicable to arbitrators, but there is also good practices that should exist in the conduction of arbitrators, not only from the perspective of arbitrators themselves, but also from the counsel or the attorneys who represent parties, and even experts or any other parties that are involved in an arbitration. So there is a task force that is drafting these standards of practice with the ICA. So it would be great if you could share with us, your to the extent possible, what has happened with this project and where it stands, where it goes. In general, if you could talk about it, we would appreciate it.
Thank you for that introduction. You're talking about the ICA task force on, it's called the Standards of Practice in International Arbitration. The shorthand that we use is civility in practice. And I have it's done. I have a copy, but it has not been released yet because ICA released just last week a big gender diversity report of a very large joint task force. So we wanted to make sure that this second task force report got enough airtime. So it'll be released very soon. And what it does, as Carlos says, is set out general principles. There are 6 for everyone involved in arbitration. There are 4 for party representatives, 4 for arbitrators, and 2 for others, by which we mean experts, witnesses, and tribunal secretaries. The co-chairs were Guido Tawil and Abby Cohen-Smutny, and I think there are about 15 other very diverse task force members. I don't want to take away their fire from the release, but I can mention a few of these general principles. For everyone, it says, all participants in an international arbitration shall act with integrity, respect, and civility vis-a-vis other participants in the process. The second principle is all participants shall respect all forms of diversity and cultural backgrounds represented in the international arbitration community and refrain from any form of discriminatory conduct. There are more, but then for counsel, I think this is where they're breaking some new ground to have a code. One principle is party representatives shall act cooperatively with each other and the tribunal, and in doing so, representatives shall use all reasonable efforts to comply with tribunal directions. And second, party representatives shall at all times act with respect and courtesy and conduct themselves in a professional manner. They shall not act offensively or with disrespect. Now, for equality, for guidelines for arbitrators, one is that arbitrators shall address all participants in a courteous and impartial manner. And a second, that arbitrators shall not employ hostile, demeaning, or humiliating terms in written or oral communications with participants. So I know what you're all thinking. Those are so basic, such basic principles of professional and human interaction. Why do they need to be written down? One answer is to come back with another question, which is, why do we need a code of conduct that says arbitrators who are deciding questions of great magnitude for parties have to be impartial and independent and be willing to examine themselves to make sure that they are in terms of a code? Another answer is by having a task force like this and a comment period that will follow, we have to have the conversation. We have to have the dialogue. As it was said in the introduction of this webinar, there are issues that even if they seem to keep coming back, and we're tired of them at Tilney Hall or wherever, they're not resolved. We're not resolving things. So I think there's a benefit to the process of putting down in paper what we think should be guidelines. And to be more, maybe more, what's the favorite word now, granular. This morning I woke up to an email from parties in an arbitration attacking, I'm not the chairman, but attacking the chairman for really hostilely, for forgetting to change some addresses in the council list. And I've seen some extremely bad behavior between counsel on both sides in my own cases, and have felt like at the very beginning, I have to call for civility and be willing to step in, even though it's uncomfortable, particularly if it's two fellow US litigators just behaving like they normally behave and saying, no, it's going to be different here. So that is a sneak peek at what will be coming out. I think it may be next week from ICCA as a next publication for discussion.
Thank you for the heads up. It's really interesting, and we're looking forward to being able to read it once it will be published. Thank you for that. So moving on with a different topic, which is also of the highest importance. We all know that there is this tendency on looking for some entities that may assist parties in the capacity of funding the cases. It is more common for claimants, but in some cases also respondents may have to have the aid in order to being able to face all the costs that are associated with an arbitration. And so this has become an important topic because it has a number of implications, eventually ethical implications related to conflicts of interest, etc. So I think following the same line of thought that you were conducting in the previous two topics that we addressed, it would be great if you could share with us your views on this very important topic.
Thank you, Carlos. May I first ask, I assume that third-party litigation funding is legal and available in Mexico, but I may be wrong. Is that correct?
Yeah, it is not regulated as far as I know, unless my colleagues know something different. So in principle, it should not be forbidden, but this is a new practice to us.
Thank you. You know, it's a little bit of background. I am a US lawyer, and I started, like many US lawyers in international arbitration, doing US litigation. So I was familiar with contingency fees. And one of my two most regular defenses of the US litigation world is to remind people that without contingency fees, we would not have probably warnings on cigarette packages anywhere, because it was the availability of contingency fees that allowed lawyers to go after the cigarette companies, asbestos, cotton dust, discrimination, you name it. So there's a very important role for justice in allowing regulated contingency fees. They're abused. Yes, there's ambulance chasing, but the ability to fund an important litigation or arbitration with help from a bank or from a third-party funder is important. And I was in Singapore over the time that third-party funding, and Hong Kong actually, when third-party funding in arbitration became legal. And there were endless debates, talk about repeat debates, about whether the laws against champerty, it was called, should be changed, were had. And cynically, some of the reason that jurisdictions are allowing third-party funding first in arbitration is competition. The jurisdictions don't want to lose arbitrations to a jurisdiction that allows third-party funding, because we had a great deal of uncertainty in Singapore, for example, whether a Freshfields lawyer who was working on a case at her desk in Singapore that was third-party funded, but otherwise taking place outside of Singapore, was at risk under the law. Anyway, that's all background. I'm in favor of regulated third-party funding. It's here. It's not going to go anywhere. It's allowing claimants to bring cases that they otherwise could not. However, the reason I put this on the agenda for today is the debate is really evolving. And I have to be careful here because these issues are in front of me in cases as an arbitrator. I think, I haven't written about this, but I think it's the consensus view is that if a party has third-party funding, that should be disclosed. The fact that there's third-party funding and who the funder is should be disclosed, if only so the arbitrators will know if they have a conflict of interest in that they're doing other cases involving the funder, or if they have partners who are counsel in their law firms that are getting funding from the same funder, that can be known, because we all know it's disastrous. At the very end of an arbitration, the award's been issued and suddenly there's a letter that says, oh, the chair of that tribunal gets the benefit of funding from, Burford in other cases as her partners or whatever. So that seems easy. And then the next step is, I'd rather not, I've said this in public awards, I'd rather not know the terms of the third-party funding. Because if I know the terms of the third-party funding, then that gives away litigation risk assessment by an experienced funder. And the same for the respondent's counsel. If you know that the funder is funding 10% of the case or 90% of the case, it makes a difference. But now comes the problem. Now comes the issue, which is requests for costs. At the very end, this is coming up again and again now that third-party funding is more common. At the very end of the case, where the claimant has disclosed funding but not the terms, then the claimant asks, the successful claimant, of course, asks as a cost of arbitration the fees it had to pay to the third-party funder. And I think most of you know the fees can be very, very high. A 300% uplift on the award. And big question, and it's case specific, so don't get me wrong, I'm not giving any sort of sermon on this. It is a cost of arbitration, but is it a reasonable cost of arbitration, in particular if the losing side did not know what the amount might be at a time when there could have been reasonable settlement discussions, for example. So I think this is coming up in security for costs, and it's coming up in cost awards increasingly. And I'm looking forward to more public debate about this aspect. There are arbitrators who are very open about the fact that they think that third-party funders charge way too much. I don't think that's our business as arbitrators to say what claimants should be willing to negotiate or not. But this is an area to watch out for and be very careful of. And I didn't do much third-party funding when I was counsel at Freshfield. I didn't have clients who needed it, and we refused to ever do contingency fees. But the paperwork is unbelievable. It's really a big process to arrange a third-party funding, and corporate experts, transactional experts need to be involved, not we proceduralists in arbitration. It's a heavily documented transaction that puts a lot of responsibility on counsel in a case. So, and the other thing, I'm looking at a picture of Francisco here. I think that arbitrators have to be very careful about sitting on boards of funders or giving advice to funders. Certainly would never be case-to-case review, undisclosed case review for funders, but it's an area we all need to get better at. Let me leave it at that, Carlos.
Thank you, Lucy. Yes, I agree. It's a complex topic, but an actual one, and we need to find a way to address it. And I think, yeah, the perspective also of the funders, they are entering into a scenario where they are betting on a case and incurring a number of costs. So there are several views, several perspectives of this matter which make it more complicated, and I certainly concur that it needs to be addressed and resolved. Okay, so to move on, I would like now to share with my fellow members of the Nuevo León committee so that they can also pose questions to you. First, Gabriel, if you would like to make a question, and then we will go to Camilo.
Thank you very much, Lucy. It's a privilege to be here, hearing you this morning. Thank you very much for this, as usual, very insightful answers to these very interesting topics. And I would like to take this opportunity to ask you about some new trends in arbitration. Travel and other restrictions due to COVID-19 pandemic have meant that, for instance, virtual hearings have become the new normal for international commercial arbitration, and perhaps even for investor state arbitrations. I do not know really, but probably. In your opinion, what are the longer term prospects for what we call e-arbitration? Probably this environment can reduce, for instance, costs, among some other perceived advantages. But do we have to adapt rules or even domestic legislations? That would be a question. And in a different order of ideas, if I may, I would like to take advantage of this fantastic opportunity to know your opinion about a perceived change in a paradigm we're experiencing in international investor arbitration from probably more investor-friendly dispute settlement mechanisms, for instance, in NAFTA Chapter 19, to a new, more limited or narrow in the new USMCA Chapter 14, in which we have a narrow normative content, for instance, for the interpretation of fair and equitable treatment, or an exhaustion of domestic remedies requirement that didn't exist before in NAFTA. In the WTO, in international trade dispute settlement, we're experiencing probably this change of paradigm as well, because there's a political pressure of the US and other countries towards a more political dispute settlement mechanism rather than a true rule-oriented mechanism, or at least that's a perception. How do you envision this perceived change of paradigms, and what would be the impact of this change in the future arbitration or investment arbitration jurisprudence? Thank you very much for the opportunity again. Thank you for being here.
Thank you, Gabriel. Let me turn to your second topic first. And again, I have to be careful because I sit as arbitrator now. I'm not a professor anymore. I think my answer to your question is yes. We are going to see a narrowing of investor avenues in investor state arbitration by dint of the more restrictive multilateral and bilateral investment treaties, and what's happening, of course, in Europe before ACMEA and post ACMEA. But as I've always said in discussions, including discussions involving complaints by state representatives about ISDS, the states are in control. International law is still primarily a question of interstate relations, and it is the states who draft, sign, and ratify the treaties and get to decide what rights investors will have in any sort of direct arbitration against them. I'm confident that, as Johnny and many other people said, states did not anticipate what would happen with the explosion of bilateral investment treaties. And once they did, they started to be more specific. And for example, the US has a limited number of BITs, and the US has been the leader in defining what is fair and equitable treatment. For example, an indirect expropriation when you're touching upon public health or consumer issues. So investors will have to live with what the states do. Now, of course, there are protections with sunset provisions in treaties and other aspects, but that's international law. I'm hoping it won't get knee-jerk restrictive. I'm hoping that it will become more predictable. and that there will be more access to courts instead of arbitration in good court systems. It's the same way I used to always say, Freshfields was in the early days of investor-state arbitration, in part because of my experience at the Iran-US Claims Tribunal, Jan Paulson's article, Arbitration Without Privity. And there were, if you think back 15 years ago or so, there were some pretty wild jurisdictional theories for investors in ISDS cases, which in international common law, if you will, have now been pulled back. And so counsel can say with confidence to potential investor clients, it's not worth trying that case on that set of facts, on that treaty, because we now have 10 or 20 decisions that suggest that you won't prevail. So the case law has developed this way at the same time as the governments are taking advantage of not restricting, but clarifying what the rights will be. So it can go too far. Obviously, it depends on a lot of things. Now on COVID, I have to admit, I have not done my first all virtual hearing yet. They're coming up and I'm getting prepared. I have done a lot of preliminary work, case management conferences, application hearings. So I've talked to my friends who are doing it. I think, this is just my prediction, I think that we've learned a lot very quickly, arbitrators and counsel and parties, on how to take advantage of technology. I think it's saving money, it's saving time, and it's making sure there can be more participation from many parts of the world, which is all good. However, I don't think that we will, I think we'll go back to in-person evidentiary hearings as soon as we can, and we should, because there's really no substitute for having people in the room, for assessment of credibility, for settlement possibility, for a real deliberative feel. But I do predict that we will use a virtual platform much more often for case management conferences and preliminary sessions, and save 2 travel days for many arbitrators and counsel on both sides. We'll use it for oral arguments on, say, provisional measures applications. We're going to see a lot more of it used for parts of hearings, I hope. So for example, you can imagine a situation where counsel can record or stream their opening arguments. It can be at different times in China and Houston, whatever, but then the whole tribunal gets together either in person or online to have a Q&A session about the openings. And then the hearing in person might be mostly witness testimony. And then you can wait a few days. And if you're going to have oral closings, you can have them a week later, but on a virtual platform after everyone's digested the hearing without everyone getting back on a plane. I think that's going to be good. And I can say that deliberations are very easy to schedule and to do now on a virtual platform, as compared to arbitrators having to stay longer or to fly different places. So I think we'll have a new normal, but I don't think, well, I think that parties should resist arbitrators' desire to do everything online from now on. Some people are worried about that. I'm not. I think we all miss the contact. Now, there are real worries that need to be addressed and discussed and perhaps regulated about for due process, but making sure that witnesses are not coached, making sure counsel are able, I don't know if a chat room or somehow make sure they can consult in a way that you can only do by whispering in someone's ear at a hearing, making sure arbitrators have time to take what they would normally do at a coffee break to say, well, you know, I don't like the way this is going. I think we need to refocus them on the following questions. There's a plasticness, I don't know if that's a word, plasticity, about everyone being two-dimensional that we have to be careful about. And there's also inequality of arms to worry about for sure. I'm sitting here in my nice study with nice computer equipment, and I'm in arbitrations where I know that the parties and the council don't have that access, and I'm following organizations like Opus One that will ship the necessary equipment, including generators, to arbitrators and counsel at different places in the world. And I think that Maxwell Chambers and the IRDC or IDRC, whatever it is in London, and other institutions that are very quickly developing leading expertise in doing hybrid hearings, part online, part in person, and facilitating Zoom hearings are going to be much in demand. It's quite something. As you know, you've got the transcript, you've got the witness, you've got the documents, you've got your chat room all at the same time. And the innovators are going to make our lives easier, and they'll make money in the process. So, but I do miss actually being in the room with the people. And one other point I want to raise about this, Gabrielle, is it's something that I don't claim credit for. But Larry Shore has said this twice in conferences that I've been in, which is that you've got a new bias to worry about, which is if I'm doing a Zoom hearing and one of the counsel is someone I know personally from other hearings and am familiar with, and I don't want to say trust more than the other side, but I have reason to know that this is a good counsel with a lot of integrity and civility, and the other person is unknown to me. I'm not saying I would be biased by any means, but there'll be a different impact on arbitrators with people who come from the old world of real life hearings and people who are new, who aren't personally known. And we have to think of ways to make sure that we don't have unconscious bias when that happens. That's all I'll say for now.
Thank you, Lucy. I miss real life as well.
Thank you, Lucy. That was very interesting, and I concur.
Oh, Carlos, can I interrupt to say?
Yeah, go ahead.
Because this is on my mind. I also think we need to give thought about what to do with strategic arguments by usually the respondent about, no, it has to be in person because my witness is important. You have to see this person, and therefore we can't have a hearing until we have a vaccine. We're talking about doing a study at ICA it was suggested by others to collect all the mandatory laws in the important venue jurisdictions about oral hearings, in-person hearings, so we know what the law says and start collecting the case law on enforceability questions that are going to come up from awards after virtual hearings. And then there'll be essays that go with it to give the theoretical underpinnings of due process and oral hearings, etc. This is new to most of us, so we do have to give consideration to that. Sorry, Carlos.
No, I agree with that. And in general, what I was going to say is that there are a number of opportunities that derive from this pandemic in terms of the e-arbitration, as Gabriel was mentioning, but at the same time, certainly there are a number of challenges and things that are going to be, that will require a regulation, not necessarily from the laws of the states, but eventually just amongst the parties that intervene in cases or by the institutions. Okay, so in order to end with this round of questions for the interview, and before we can move on for the questions to the public, I would like to ask Camilo, certainly not last but not least, to ask his question, which I know is a very important one. Please, Camilo, go ahead.
Thank you, Carlos. And thank you, Lucy. As Carlos said, this will be the last question on our side. And it has to do with gender diversity in international arbitration. You mentioned the recent release of the ICA report issued by a task force on gender diversity in arbitral appointments and proceedings. This report, among other information, shows statistics on the appointment of female arbitrators. And on this point, I would like to mention some numbers. with respect to ICC arbitrations, the new cases registered in 2019, there were appointed arbitrators from 89 jurisdictions, and the proportion of women arbitrators reached 21%. In a similar number, the ICA Task Force report mentioned that since 2015, the proportion of female arbitrators has almost doubled from from 12% in 2015 to 21% in 2019. So the question is, could you give us your opinion about the practical ways to increase diversity in international arbitration?
Thank you. This is one of those topics that, as Carlos said, is we talk about and we talk about, but it stays relevant because it is somewhat stubborn. I guess at the end of the day, what I would say, Camilo, is we have to keep trying because our efforts are working. And I talk about this a lot. What's the conversation? The conversation on gender diversity is very robust now. 40 years ago, it was not when I started practice or longer. It was still very rare and the attitudes were, well, sort of prehistoric. But now it's front burner. The institutions deserve a lot of credit. The ICC, this is ICC, the ICC deserves a lot of credit in appointing more women arbitrators, in the new policy under Alexi Moore to publish the names of arbitrators in all the cases. This provides not just statistics, but it helps those who want to make new appointments to see who's been appointed in order to look for new names. I am all in favor of that. We know that the institutions are doing a good job. LCIA, I think, is 50% women now. SEAC is doing better. But the parties are way behind. I think chairpersons will name, I don't know, maybe it's 20% of, I'm sorry, co-arbitrators will name maybe 20% women, but the parties are still well below 10%. Why is that? That reflects that, and I well remember from my days at Freshfields appointing arbitrators, you need to recommend to your client someone with whom you're familiar and you trust. You may not win the case, but it's someone you know, and it tends to be the repeat people who are older male arbitrators. So this is where the pledge has helped, I think. I call for those of you who don't know, the pledge boils down to this. I call it the 5-minute rule. Under the pledge for gender diversity in arbitration, when anyone's in a position to be recommending a person or a slate of people for arbitrator appointment, you should think longer and harder about what women fulfill the profile for the arbitrator. And believe me, I'm as guilty as anyone when people would come to me and say, oh, who do you think would be a good claimant appointed arbitrator in this commercial contract case? Johnny Beater, Jan, Bernard, you name it, all those names come to my mind first. Gabrielle's in there, Brigitte Stern is in there, Carolyn Lamb, but they're not so many women. But if I stop and really think, I can come up always with several more women. They may not get selected, but you get on the list, and that's how it goes. So I think we have to keep using the pledge, and women and men alike have to be promoting more women. Two things I want to say are, I'm more worried, not worried, my greater concern at ICA right now is other types of diversity. Diversity of nationality, ethnic diversity, geographic diversity, because those numbers are atrocious in terms of Africa and even, Central America, other places. So it's up to other people to come up with a pledge. But the conversation hasn't really started in a serious way, the way it did 40 years ago for gender. So that is something that I'm trying to devote more attention to. Another point I want to make is, and this comes up in the ICSID UNCITRAL Code of Conduct, people have said that if we allow double hatting, we will be promoting the career. We will make appointments of younger arbitrators and women arbitrators easier because they tend to be in law firms. And double hatting covers law firms more than individuals. And if we don't allow a promising senior associate from one of the big international law firms to be appointed arbitrator because her partners are doing arbitrations, then we're losing a lot of the pool and we're not promoting the career. We can never compromise ethics for promoting diversity. I'm sorry, I'm a real hawk on that. But that doesn't mean there isn't more room for more women and younger arbitrators. They're just not going to come from the very big practices. They'll be from smaller firms where the partners aren't doing investor state arbitration, or boutique firms. So I think we have to be cautious of that dialogue, in part because the first person who made that argument to me was a senior male partner from one of the top international firms who was frustrated that he couldn't sit as arbitrator while also being a highly paid partner in a law firm by a double hatting rule. So we have to keep trying and give ourselves about a decade, I think, to see real change. I've written about this, and culture-wide, there's a ceiling in gender diversity at about 16%. It's a magic figure that Deborah Spar, who was a professor at Harvard Business School, did a study. Accountant partners, law firm partners, professors, surgeons, you name it, when the pool gets to 16% women, around there, 13, 16, 20 max, it stops. And that troubles me a lot, because what that shows is that if you get that much gender diversity, you think you've done well enough, which doesn't make sense because women are 50%, maybe a little more, of the world. So I look at the pool of arbitrators and I say, oh, well, I've appointed 2 women in a row, so now I don't need to worry for 10 more. You have to approach every panel, every appointment with true diversity. Who's the best person or the best slate of people for this case? And let's add some people who are a little bit newer, who don't have quite the pedigree or the track record, and get their names in play. So I've probably said too much, but I'm optimistic. I mean, I've seen it. I have fortunately not experienced myself any discrimination based on gender, but I've seen a lot of it for sure.
Thank you, Lucy. Yes, I concur with your idea. In a reflection that I have always had is that in law school, at least in Mexico, and I think that is true. Well, I have studied in France and in New York, and I think that is true, and that should be true. That should be true elsewhere. There is an equal number of female students as male students. So what happens afterwards? So I think there should be more access, since they are studying, and in many times they work harder than us men. So I think there should be a more ways in order to improve the access in all aspects of arbitration. Well, thank you very much for this round of answers that you shared with us, Lucy. We appreciate very much. And now I would like to open to the floor to our commission members and our guests who are here in the public. What I propose, in order so that we can respect an order, is that if you have a question, you write down your name in the Zoom group chat so that I can follow the same order. It can be a question, or it could be just a reflection or something that you would like to share from what Lucy mentioned. So I already see here Francisco's name. So please, Francisco, go ahead.
Thank you, Carlos. Congratulations on this session. Thank you, Lucy, for being with us in Mexico. I was of the many very interesting things you said, I was particularly interested in the topic of issue conflicts and double hatting. May I pick your brain? What's your view on the position that issue conflicts, or the current rule in the ISDS Code of Conduct, draft rule in Article 6, that would make a blanket provision for double hatting is over prohibited? That we should be mindful of issue conflicts, but one doesn't necessarily need to get the other. And instead of having a blanket rule, we would be better off, because of how complex scenarios are, with a test in the nature of what the ICCA report of a few years ago advocated for, to see how committed the arbitrator is, how if there's concurrency between the acting as arbitrator and advocate, and how close these proceedings are. How would you feel about those? Because you mentioned, by the way, in the context of issue conflict and double hatting, something that led me to think that maybe, and also in the context of having to choose between ethics and gender diversity, I query whether there's a false dilemma there. Maybe we could have both, but I'm interested in your views.
Sure. And the first thing I want to do is highly recommend a paper that Francisco has written and shared with me on issue conflicts, labeled or entitled "A Net Cast Too Thin." This could be a whole 2-hour discussion, obviously. And my bottom line is this. I do not think that in a code of conduct, there should be a blanket prohibition on double hatting. We would lose too many good arbitrators and too many good counsel. And as you say in your paper, well, because it's important to define what's a true issue conflict. That's very rare. The fact that, say I'm still counsel in a law firm and I'm arguing fair and equitable treatment in tariffs and telecoms in one country under one treaty in one case, but then I might argue about fair and equitable treatment in a completely different sector, completely different fact situation. That I'm not worried about issue conflict there, because I think independence will prevail. And it doesn't make sense to say a given person can never play both roles in order to avoid a proper issue conflict. I'm with you, Francisco. I don't think that issue conflict should be measured against what people write in articles, in their publications, on their view of, to go back to an earlier question about what's my view on what the governments are doing to narrow, some would say, or better define, some would say, fair and equitable treatment and indirect expropriation. Unless I'm stupid enough to write, and some people are, to write, under no circumstance would I ever find in favor of a investor on fair and equitable treatment because I don't believe in it. I mean, people get surprisingly close to that sometimes, but publications, I think, don't count. I think it's very important to remember that arbitral decisions come from 3 arbitrators, and you can't say that even the chairperson wrote it and took a position in a prior case with confidence. So I think we have to narrow real issue conflict. I think what I worry about, I don't know how many people on this call are practitioners as in law firms as compared to independents. My perspective comes from my experience at Freshfields, where we were the first group, and it was my insistence that we regulate at Freshfields double hatting. And we said, no Freshfields counsel can be an investor state arbitrator, period. And why was that? Because too often the issue conflicts come up late in a case. And it's as the facts develop that someone sitting as arbitrator realizes that her law partner is arguing a very similar position to another tribunal at the exact same time. And then ethically, you have to leave an arbitration as an arbitrator very late in the game, which is bad for the parties. It's bad for the clients of the law firm. It causes a lot of tension. And in the big practices, you never know. I mean, you might take a case as an arbitrator, an investor state case with a nobody company, but then it becomes a target in an IPO that your corporate partners are looking at, and they tell you, you're going to have to resign. I don't care that you've already had the hearing. This is a multi-million-dollar case for a very important client, and you're working on your own. You don't have any associates. You're not making us any money. It's a hobby sort of thing. So my perspective comes from the heartache that comes when a true issue conflict emerges late in an actual arbitration. But that could be regulated by the law firms or by the academic departments, for example, but not, I don't want to see it in a flat rule. And it's an area that's very delicate, and I certainly don't, that's why I don't want to see the fact that an individual can't do both. I hope that helps. It's I didn't have time to tell you, I think it's an excellent article. And for those who haven't read the task force, the focus is on, in an individual appointment or case, what's the degree of commitment that was shown by the arbitrator's prior work, the concurrency in time and proquinity, concurrency of service, how old it was, and the proximity to the specific case.
Thank you very much, Lucy.
Thank you, Lucy. We have 4 more questions that are written down in the group chat. So I would appreciate it if the questions can be brief. We will follow the order as they ask for to intervene. So Mr. Ogario, then Luis Enrique Graham, then Rodrigo Zamora, and then Mr. Klaus von Balleser in that order, if you will. So please, Mr. Ogario. You are on mute.
That's the phrase we're all getting used to in all languages. Yeah. You're on mute.
Yeah. Lucy, you mentioned in connection with third-party funding that the fees or the part of the award that the funder receives is part of the cost of arbitration. Are we to understand that in case of a party losing an award and the funder receiving a substantial part of that award is to be considered as a cost in addition to the award, so that if, for instance, the funder agreed to fund the case for 50% of the award, and then the funder is paid 50% of the award, that this cost of the arbitration should be in addition to the award, and that it should be, let's say, the losing party will have to bear the burden not only of the award, but of an additional 50% because of the third-party funder's share of the award?
I see I got your attention on this point. And to be very clear, no, I'm definitely not saying that that should be part of the cost of the awarded. What I'm saying is it's being claimed now by the successful parties in many cases on the theory that, say the award is for $1 million, the successful claimant will say, I've won. The arbitrators think that I should be owed $1 million from my, the other contracting party, but it cost me $600,000 to pay for the third-party funder to fund this arbitration, and I'm only going to go away with say $300,000, and the market cost of third-party funding, we know from the good funders, is always a 3 times uplift. Therefore, I should be reimbursed for that as well. I'm not saying it's due. I'm not saying it should be awarded, believe me. I would never do that as a sitting arbitrator. Issue conflict, this is where we get into issue conflict. I'm just saying these cases are coming up, and there are aspects of third-party funding that we haven't thought about when we just talk about access to justice, of the right for people to get third-party funding without focusing on the cost of it and the parameters of it.
Thank you.
I want that to be very clear but that's an issue before many arbitrators right now, and it can be very case and fact specific. And my point is disclosure in advance may become more common because the terms which aren't disclosed become relevant when there are claims for costs at the end of the case.
Thank you, Lucy.
Thank you, Lucy. So we can now go to Luis Enrique. Go ahead.
Thank you. Lucy, it's great to hear you, just like in your interventions at Junsin trial. Always brilliant.
Well, I don't know about that. I hope practical.
I would like to get from you further views as to, and I want to refer to the dilemma, the battle that now we see or we have seen for some time with respect to the confrontation between either regulation vis-a-vis over-regulation. And I think that we have some very good examples of things that have been within the side of proper regulation that have been extremely helpful. And just to name three that come to my mind, and there are many. I don't want to discriminate unfairly other very good exercises of good regulation or good guidelines, I would say. One, for instance, the rules on take it evidence of the IBA. I think they have been and proved to be extremely useful. The UNCITRAL notes, of course, the ICC guide to save costs and time in conducting the proceedings, just to name a few. But we have some, and you raised some examples of areas in which probably we are going too far. And like in all things in life, I think that the challenge is to be in the middle, to find the right balance. And with that frame in mind, is there any particular area with the best experience that you have in which you truly think that there is a need for additional, I would not call regulation, but additional guides?
That's a good question. I'll start by saying I agree with you that there are soft law guidelines that have proved very helpful, and you listed the first three that would come to my mind. And they're helpful because they don't have the numbers X in them. They don't have hard parameters that will make people, that can't apply across cases. So that's why I don't think that we'll benefit from regulation that says no arbitrator can ever, in international arbitration, let's leave it at that, no arbitrator can ever be counsel in another case. No arbitrator can have more than 5 investor state cases. You only need to disclose connections to the parties that you've had in 5 years. What if they were my best client 15 years ago? I mean, I think we should stay away from hard numbers and trust our intelligence to use guidelines. The one area that I can see where we're going to need guidelines, and perhaps with a capital G, is just what we've talked about on virtual hearings and on recurring instances that touch upon due process and fairness and efficiency and equality of arms in virtual proceedings that we'll be seeing more of over the next 10 years. And I think that groups will be focusing on this. Third-party funding, I think, requires probably more regulation, both from the funders and from national legislation in sites of arbitration, venues for arbitration, on disclosure. And as I keep saying, at least we have to have the conversation. And if the conversation ends up with general principles like we have on civility and the new ICCA standards of practice, that's fine with me, because a lot will come out in the open. And I keep thinking, you know, in the ICSID rules, there's 41.5, which says that arbitrators have a responsibility to dismiss a case early if it's manifestly without legal merit. That's what we would call summary judgment, of course, in the United States, and a dispositive early decision in other jurisdictions. It's we've seen there's statistics that show that arbitrators are more willing to do that when the specific set of rules says it's okay. It's always been okay. It's part of arbitrators' management of their cases to make a summary judgment, a summary disposition if it's a hopeless case. But it's just easier if it's written down somewhere and you can point to it. So think about our civility guidelines. I think it will be helpful, like the IBA rules, for arbitrators to say when counsel are really misbehaving, whether that's their cultural or not, to say, look, you know, we're looking to these guidelines and they say there shouldn't be offensive, what the other side considers offensive conduct. So guidelines can be useful. Hard numbers, not so much. Third-party funding, I don't know. We might see some jurisdictions limit the financial terms that third-party funders can impose, just as we have limits on contingency fees in the United States. Long answer, sorry, good, hard question.
Thank you, Lucy.
Thank you, Lucy. Now we move to Rodrigo Zamora. Rodrigo, please.
Thank you, Carlos. And Lucy, I join in thanking you for being with us today. We have to take some of the advantages that we have gained this year on this type of online communication. So we very much appreciate your time. I know that for quite some years, there's been discussion on how some of the issues, procedural or substantive investment arbitration, have moved over to commercial arbitration. And one of those certainly has been transparency. I can understand some of the thoughts and ideas on why a large volume of the file in investment arbitration is public, including obviously many awards. And we have seen now a movement, for example, by the ICC, in which under certain considerations, and of course, taking very much into account the decision and consent of the parties, to publish awards sometime after they have been issued, and this will start, of course, in the coming years. Do you have any thoughts? I mean, I just wrote an article for a South American journal, but I don't know if you have any specific thoughts on pros and cons on where this might lead, by knowing if I see an award and I see that Lucy interprets contracts more broadly or more strictly, or whether she thinks certain grounds of annulment in an award that she issued can be used in another case that I have, I don't know, and of course there might be other considerations for this publicity. Again, I guess we're just going to start living with it, but I wanted to, as Francisco said, to pick your brain and take advantage of having someone of your stature with us. Thank you again.
Welcome. This is a very common topic. In fact, there are discussions already about the UNCITRAL ICSID code of conduct, whether it can be, when it's enacted, whether it can apply commercially. I think, you know, the history to the full transparency of investor state, or almost full transparency, or I think you'll have to, pardon me, I think that's my husband's phone. The issues are repetitive. They're treaty issues on the protections of expropriation, fair and equitable treatment, full security, and the states write the treaties and they're going to be subject to repeat interpretation. Therefore, it's always made sense to have the awards available for a common international law. It started actually back at the Iran-US Claims Tribunal, where in a certain extent, miraculously, Iran and the US decided in advance that all the decisions on contract breach and expropriation of that tribunal would be public, and that formed the basis of the law that we used in the early investor state cases. This makes sense to me. It's the development of public international law and principles. Commercial arbitration is still primarily meant to be confidential between business entities, so that they can, I'm not talking about the giant cases, but most cases, so they can't resolve it, they need someone to resolve it, then they get on with their business. And they're going to be fact specific as well as contract specific, so they don't add that much to the law. And we don't need that. We don't need that for legal development. It is interesting for evaluating arbitrators, of course, as you say. I have some sympathy for arguments that some English QCs and law lords have made about private justice is depriving the public and other lawyers of the development of commercial law, because we don't have access to ICC as easily ICC awards. But in general, I think there's not as much lawmaking in commercial arbitration as there is in investor state, or at least law interpretation as investor state arbitration. I do like seeing the redacted awards though, because I look for things, commercial awards, costs, I think are interesting to look at. Evidence, use of evidence is interesting. Burden of proof is interesting. Basic commercial, application of basic commercial rules like pacta sunt servanda are interesting. You cannot, however, underestimate the expense of redacting commercial awards in a way that doesn't inadvertently disclose who the parties are or what the contract is. It's really difficult to do. The AAA has tried over the years. So that wasn't a very good answer. I think only certain level of commercial awards benefit the public from full disclosure or redacted disclosure.
Thank you very much.
Thank you, Lucy. And next, and probably this will be the last question, Klaus von Boviser, please, Klaus.
Thank you very much, Lucy, for your insights. It really was a fantastic talk. I think the review was great. Congratulations to my colleagues from Nuevo León. I wanted to ask or make a comment and then have a question. I'm very much concerned, as you are, with this new guidelines on disclosure from ICSID and UNCITRAL. And I had a recent case where this already had an effect, these new guidelines. I was proposed as a chair person for the tribunal, and my name was proposed by ICSID to the investor and to the state. And they asked for comments. They proposed, I guess, different candidates. At least they proposed my name. And then the state came back and sent a letter and said that they wanted to know, of course, a list of all the articles I've published, although I've published many articles many years ago that have nothing to do with investor-state arbitration, as you correctly state. I'm not the type of person that keeps a record of a list of, I have no idea. I would have a hard time finding them, putting them together. Second, they asked I should reveal all the contacts I had with the lawyers on the other side, the arbitrators. Not only me, my partners, my former partners, and of course, it was a way of clearly that they didn't want me as an arbitrator, clearly. And then what do? I mean, you say, look, I don't have that information, and I don't, and clearly that law firm is very active in international arbitration. I had them probably in my house, probably in many IBA meetings, many ICA meetings, as dinners. I mean, we have contact, and probably the guys you have not had contact, there are very few that are in this world of international arbitration. So what do? And to what degree you believe I mean, because if you simply say, I don't have the information, but I still don't, I put my name forward, then, you know, there will be a challenge. And it will be very, very unpleasant. Or do you think the institution should take a more active role and do not permit that type of questions? I mean, should ICSID say, I mean, the list of stuff to be revealed doesn't make any sense, and it should be rejected, because otherwise it will be impossible to constitute a tribunal because there will be all sorts of tactics by one side or the other side, or as you correctly say, you forget the case you had in Freshfields where you were not even involved, even you were head of that practice, one of the biggest firms in the world in international arbitration. How could you know that one of your partners had a small case on something, and then you will have a challenge, and probably the challenge will be upheld because if you didn't reveal something. So I think it's a terrible idea, and I think it will create all sorts of problems. It's already creating because it sort of gave ideas to parties of using this in a malicious way. So what's your recommendation? How to stop it? Because it could, as you correctly state, create a huge problem.
Thank you. Thank you, Klaus. I've heard this story from many, and it goes back to Luis Enrique's question. As soon as a code of conduct uses the word all, must disclose all publications, not even relevant, tied to the disclosure obligation, tied to continuing disclosure, then we're defeating what we should be doing in international arbitration. So what I think people should do is comment to ICSID and say, this is an overly prohibitive rule. The rule should be disclosure, as it is now, of relevant publications. And most of us have them listed on our CVs or on our websites anyway, and therefore make it a trust in our independence and integrity to disclose what is important, and recognize there'll be some variation. So I don't like all, I don't like 10 cases, I don't like no double hatting. I don't think that will help us. It takes away our judgment, and we're going to end up, as some people say, with, you know, my art historian daughter will be the only eligible arbitrator at some point with no connections. Another thing in the code of conduct is you don't have to disclose things that are quote unquote trivial. That's the opposite side, Luis Enrique. That's so vague. What I consider trivial is going to vary with what other people consider trivial. For example, I'm very close friends with some people in the arbitration community. I've gone on vacation with their families. I regularly socialize with them. I don't disclose that. I just don't, I don't volunteer to be in cases with them because I don't think that's trivial. Other people think that doesn't matter. That professional conferences, I don't think we should worry about. I agree with that, but there are close friendships that I think would. So as I said at the beginning, Johnny Veeder said, and it's always stuck with me, if we don't quote unquote regulate ourselves in our acceptable conduct and rules for disclosure, others will who don't know the way that we work. It can be national legislators, it can be academics, it can be full-time bureaucrats. So we have to stay in the conversation. And the last thing I'll say, I meant to say it before in response to a question on regulation. Juan Armesto and the Spanish and others are very vocal now in saying that how come there aren't any codes of conduct for arbitration institutions and for those who appoint arbitrators, and why don't we know more about how their appointments are made? Interesting, an interesting area for another day.
Don't you think, Lucy, that the ICA should take a more active role in signaling those points to ICSID and UNCITRAL and IBA, and that because I think it's a moment to stop this. I mean, I think I think many experienced arbitrators would share the view. And you have the IBA guidelines on conflicts of conflicts, which establish not that it should be revealed if you have more than 3 appointments in the last 3 years. I mean, there's a certain rule with number, but it makes sense. Nobody has gone against that one. But I'm not sure if we should do something, because otherwise it will come through and it will create problems.
I know that a lot of ICA members and officers are giving comments. I think the process of getting to speak as ICA would be very difficult. Task forces are given their own voices, but let me think on that. Right now, we're spending a lot of time thinking about, talk about the future. What are we going to do with the Edinburgh Congress? What are we going to do with congresses in future that bring 1,000 people to some one spot in the world of pandemic and little air travel? So, but these comments on the code of conduct don't have to be elaborate. You know, they can be just one paragraph that say, I'm concerned about the overly prohibitive language in the following 3 draft clauses because that'll limit the pool, full stop.
Perfect. Thank you very much.
Thank you. I'm glad you had the first and amongst the last words. And I really enjoyed that that ICA meeting in Mexico City last year and look forward to something in Monterrey soon, Carlos.
Thank you. Thank you very much, Lucy. Thank you. Thank you, Carlos.
Thank you. Well, Lucy, I think the purposes of this session were perfectly met. They were twofold. On the one hand, of course, to have our session and meet to discuss about very interesting topics, and secondly, to dedicate to some sort of a recognition, a very humble one from my part at least, to all of the work that you have done in the field of arbitration, and I'm very satisfied about it. I always enjoy listening to what you have to say or to write. It was a very satisfying event, and I appreciate it. I need to conclude the session with some housekeeping things. Please feel free if you need to continue your tasks or if you want to stay as you wish. I'm going to switch to Spanish. Anyway, we will be brief. And thank you again, Lucy. Muy bien, pues muy brevemente, nada más para concluir la sesión, voy a dar algunos mensajes. Podría darlos en inglés, pero creo que es más sencillo y eficiente para todos que los mencionemos en español. Pues bueno, la primera es mañana y pasado tenemos sesiones de comités, Bajío y Jalisco. También va a haber temas muy importantes e interesantes como los que hemos tenido ayer y hoy en materia de propiedad industrial y en materia de arbitraje deportivo. Al mismo tiempo se les invita al diplomado de arbitraje en línea, que va a tener lugar en lugar del que íbamos a tener en Monterrey. Sabemos que pues, la situación nos lo impidió, se va a mover para el próximo año si las circunstancias lo permiten, pero se abre una muy buena oportunidad de hacerlo en línea y creo que eso va a fomentar que se inscriba mucha gente y seguramente será muy exitoso. Entonces, para mayor información al respecto se pueden acercar con Laura para más detalles. Igualmente se les invita a que se registren en la base de datos de árbitros y peritos. Igual, pues bueno, quienes no sean miembros todavía de nuestra institución, pues que se adhieran. Y pues bueno, pues básicamente quiero reiterar el agradecimiento a todos los que nos acompañaron hoy, en especial a nuestra invitada de honor, a Lucy Reed, y desde luego a nuestro presidente de ICC México, doctor Klaus von Boeser, y al presidente de la comisión, licenciado Alejandro Garrio, vicepresidentes, licenciado Carlos Loperena y Víctor Ruiz, en fin, pues todos los que integramos esta gran organización. En lo personal yo me quedo con una muy grata experiencia de esta sesión. La verdad es que creo que estamos aprovechando esta oportunidad de tener pues sesiones no físicas y pues bueno, ojalá que podamos seguir coincidiendo en el futuro. Ya les haremos llegar la invitación para nuestra sesión de octubre. Muchísimas gracias a todos. Tengan un muy buen día. Thank you very much to everybody. Thank you, Lucy, again.
All thanks are from me for your including me. Have a good day.
Thank you, Lucy. Gracias a todos. Hasta luego. Gracias.
Gracias, muchos saludos. Chao.
Saludos.
Saludos a todos. Un abrazo y gracias.
Saludos a
Gracias
todos.
a todos y que tengan un muy buen día.
Igualmente.
Gracias igualmente. Nos vemos mañana. Gracias.